but I am the education director, as Marichelle said, and I think we have a great program in store today with the Savvy Seniors here. Richard Hibbert is the coordinator of the Savvy Seniors at this time. And I think we have 3 Savvies out of a troop of 11, if I'm not mistaken. And we have Caroline Earle, who's an estate planning attorney. She's here to present to you today. And David Gold, who is a financial advisor with Edward Jones. And I'm going to let the Savvies begin because they have a great opening skit and it will tell you a little bit about them.
Okay, Richard, good afternoon, everyone. My name is Dick Hibbert, and as Anita said, I am kind of the coordinator for our Savvy Seniors program. Savvy Seniors is a group of volunteer actors who are connected with Lyric Theater, and there's an arrangement, an agreement between Lyric Theater and COVE for the Savvy Seniors to be an arm of the COVE program as part of their senior Medicare patrol. Savvies were formed in 2008, and actors have been recruited to learn these skits and to share them. And we travel around the state, and we've gone out of state a couple of times to do programs at senior centers, senior residences, churches, community centers, different places where people have gathered to learn primarily about Medicare fraud, waste, abuse, those kinds of things, but also about internet scams, telephone scams, identity theft, those kinds of issues that affect seniors, and try to help people be aware, be educated, and to be more proactive in taking care of themselves. Most of our skits were written by a founding member of the Savvy Seniors, Ken Wolvington. Today, we are going to do 3 skits. The first one is called What's in a Name, and it was written by Ken. The other 2 were written by 2 of our newer Savvy Senior members, Kimberly Rockwood and Peggy Bonesteel. So I think I'd like to introduce the Savvies who are here. So as I say your name, just kind of wave at us. So first, Audrey Arnold. There she is. You all could recognize Audrey because she's the one who is most dramatically clothed today. Peggy Bonesteel and Kimberly Rockwood. And those 3 ladies and I will do the skits that we have for today. Another member of our Savvy Seniors troupe is Rita Myers, and she's on the call today as well. So there she is. So we're going to begin with a skit called What's in a Name, and this is about looking at your own documents, your own policies, your own issues, financial issues, to be sure you know where your policies are and who the beneficiaries are and those kinds of things. So Audrey Arnold and I will be sharing the skit What's in a Name. I'm going to ask, just so there would be better visibility, that all of you who are not involved in this, put this on a speaker view so that you can see visually a little bit better what Audrey and I are doing. To set the scene, this is an attorney's office. The attorney's name is Fred Stoneheart, and his client is Margaret, and she is coming in to talk to him about some insurance policies. Come in, Mrs. Bother Me Not. Please have a seat. Can I get you a cup of coffee?
No, thanks. I had coffee on the way here. I really would like to get right to this.
Of course.
I do hope we can get this settled quickly and easily. there are the funeral expenses to pay. Good heavens, outrageously expensive. I think the mortuary must have thought my husband was Jeff Bezos. Then there's the repairs going on at the house at Vale, not to mention fixing the boat and bringing it back from Capri. It goes on and on.
Yes, Mrs. Bother Me Not. I'm sure you have a lot of expenses. Now, are you aware of just how many insurance policies your husband had?
Of course I am. He was always showing them to me in his safe. He wanted me to be sure and to know that I was protected if he should die. I think he bought a new policy every year, and he always bought it from a different company. He said in case a company went out of business, he didn't want to lose everything. So that's why he diversified like that. Well, I know exactly.
I'm afraid we might have some problem with quite a few of these.
What problems?
Well, it's the listed beneficiaries. Here, let's take a look at some of these. Like here's one. This one is from 1952. It lists the beneficiary on here as Esther Bother Me Not. Do you know who that is?
My God, that was his mother. She died in 1975 or 76.
Okay, well, there is a second beneficiary on this policy who is Walter Crum.
Walter Crum? Oh, that was one of his army buddies. I have no idea what happened to him.
Well, that's going to be a problem for us. Now, here are some other policies. Let's take a look at well, this one here. How about Sheila Arbuthnot?
Sheila Arbuthnot? That was his first wife. They were divorced in 1967. Aren't I in there anywhere?
Oh, yes, of course you are, especially in the later years. But many of these beneficiaries are from earlier policies, and they're names that I just don't recognize. Why don't we start going through them, one at a time, and you can tell me what, if anything, you know about them.
My God, I think I'll have that coffee now, and unless you have something stronger. Oh, that damn George. God have mercy on his soul, of course. Oh, you're all going to be able to fix all this, aren't you, Mr. Bother Me Not? I'm sorry, Mr. Stoneheart.
I certainly hope so, Mrs. Bother Me Not. But it is going to take time. Probably many months. And it's not going to be inexpensive. Many hours of our firm's time. I'm afraid that you're going to have to pay for some of those expenses from your savings.
Well, that's just what I needed for my 75th birthday. Thank you, George, you dumb.
And curtain.
That's it.
So I think that, yep, that's the end of the skit. That was adorable. And Caroline and David, you can introduce yourselves and go ahead and start talking.
Yes, thank you, Anita. I'll start with Dave's permission. My name is Caroline Earle. I am an attorney in Montpelier. I have my own law firm, and I've been practicing in Vermont for the last 27 years. I actually started an estate planning part of my practice a number of years ago when my father organized his estate and when he passed away. And I handled my father's estate at that time as his executor. And I learned the beauty and the gift of a well-planned estate. I have 3 older brothers, and my father planned his estate wonderfully, which was incredibly beneficial and just a lovely gift to me, certainly, and my brothers when he passed, because he did pass unexpectedly, and it was extremely emotional. We were very close. So I took that gift that my father gave me, and I decided that it would be a great area of practice for me to share that gift with others. And so I began practicing estate law at that time, as well as some other areas of law. And I continue to practice estate planning. It's a major component of my practice. I enjoy meeting with clients. I enjoy helping them. All the bother me nots in the world and stone hearts in the world, figuring out these important issues before it is too late, and so that their families can also have that gift of estate planning. Thank you, Anita.
And my name's Dave Gold. I'm a financial advisor with Edward Jones. I've been in Barrie for 7 years. And before I came here, I worked in corporate America for 25 years. And one thing I found in corporate America is all about profits. Now my priority is all about people. And so I really appreciate the opportunity to be here with you today to share what I think is a very important topic and to give you a little bit more information along with Caroline on estate planning. I recently am currently going through the estate process with a family member. And it just highlights the importance of having a plan in advance. So I'm going to share some charts here. Okay, can everyone see that?
I can see it.
Okay, great. All right, so.
David? Sorry, this is Marichelle. I just want to say, if anyone has questions, they're welcome to put them in the chat, and we can save them for later. Is that? I just wanted to put that out there. Thanks.
And we will have time at the end for questions and answers. And I'll speak for Caroline. If we run out of time and your question isn't answered, you can feel free to contact either of us. I'll be happy to share our contact information at the end of the session. So Caroline and I have worked together for quite a few years, and we think it's very important when you're considering your estate plan that this be approached as a team approach. Myself as a financial advisor, I can't give legal advice. Caroline as an attorney can't give tax advice. And the CPA can't give legal advice. And so by each of us having an expertise, working together, we can create an estate plan that meets your goals. An estate plan should not be an afterthought. In fact, we consider it one of the 5 primary financial needs of any individual. We think everyone should have a personalized estate plan. We're going to talk about that in a little bit. So everyone's estate plan should be personalized because everybody's different. Even though everybody is different, we use a standardized plan, a standardized process to create a plan for you. And that process is as follows. We start with looking at, where am I today? This is looking at things like, what are my assets? What are my insurance policies? Who are my beneficiaries on my insurance policies? What's my family situation? Then we look at, where would I like to be? And from an estate plan standpoint, that might mean I want to be able to help my grandkids through college. It might mean I want to make a contribution to a charitable organization. The third step is that estate plan viable? Is it achievable? And then the real work of the matter is, how do I get there? What are the specific legal documents that I need in place? What are the specific decisions that I need to make? And then, most importantly, and we'll talk about this later, reviewing that plan on a regular basis. Because life changes and the world changes, and maybe my goals change. So it's very important to not create a plan and put it on a shelf for 25 years. And we'll go through our examples, we'll highlight some of that. So I really enjoyed the skit at the beginning. I've been watching a lot of Netflix over the past year, as I'm sure most of us have. And so the skits and the pieces that we're going to go through are really have a lot of that movie feeling in sticking with the Netflix for the past year theme. So we're going to start with the big reveal. And the big reveal when we talk about estate plans is, a lot of you may think, I don't have an estate plan. I don't need one. But when it comes to an estate plan, even if you have done nothing, you have an estate plan. And the reason for that is that the state of Vermont has set laws and regulations that say if you die without having your wishes expressed, then this is how your estate will be administered. And what Caroline and I are going to talk about is, how do you make sure that that estate plan really reflects your wishes? Caroline, would you like to comment at this point on anything, or feel free to jump in?
Yeah, no, I appreciate that, Dave. One thing that I wanted to do real quickly was make sure we're all on the same page as to the definition of an estate plan, because we use that term a lot. An estate plan is essentially a strategy that you develop to enhance your quality of life during your lifetime and the use of your assets during your lifetime. It is also a strategy that you develop to enhance the quality of your end of life and your asset distribution upon your death. So when I talk about an estate plan, when Dave talks about an estate plan, that's what we mean, is having that strategy. And you'll notice that I talked about your lifetime. An estate plan is not just when you're gone. There's a question in the chat box, how is this different from having a will? A will is one of the tools that you use to create an estate plan. There are many tools that are involved in an estate plan and are available to you depending on your needs and on your wishes. And a will is one of them. So I just wanted to make sure, Dave, thank you, that everyone's on the same page as to what an estate plan is.
Yeah, let's hit just a couple of other components of what that estate plan might be. So a will, a power of attorney, an advanced healthcare directive, possibly trusts. Anything else?
Sure, there can be, we've talked already a little bit. In fact, the Savvy Seniors talked a little bit in their skit, a lot in their skit, about beneficiary designations. That is definitely part of an estate plan. That can involve designations, beneficiary designations on your bank accounts. It can involve beneficiary designations on your financial assets like Dave handles. It can involve beneficiary designations on life insurance, as Ruby says. So there are all sorts of beneficiary designations that definitely are implicated in anyone's estate plan.
Great. Thank you. So we talked about if you haven't created that set of documents, if you haven't created that estate plan, then the state is going to make those decisions for you. But most people don't want the state making those decisions. most people want to have control. Control is probably the most important aspect of the estate plan. But a lot of people put off that conversation, put off the estate plan because it's hard. It's talking about death. It's talking about what happens if I become incapacitated? What happens if I can't make decisions for myself? It's a very challenging set of conversations to have. But as experience shows time and time again through personal experience, but also through the experience of my clients, it's a lot harder having that conversation after a loved one has passed. So we encourage you to put a estate plan in place and do it now so that you can be in control, so that you can decide how your money will be distributed, who will take care of children if needed, who will make medical decisions for you or financial decisions for you if you can't make them for yourself. So what we're going to do is run through a few examples of different scenarios, and Caroline will talk about what these example people may want to consider in their estate plan. But before we go to those examples, this might be a good time for a middle skit. Before we go,
okay, if we're going to do the second skit, I just want to remind everybody to mute mute yourself so that we can all be heard. Our second skit is called Probate Problems, and this one was written by one of our performers, Kimberly Rockwood, and it's a new skit. It's never been done before, so you get to see the world premiere of Probate Problems. The two players in this skit are Peggy Bonesteel and Kimberly Rockwood. The setting is starts out and Pat's home. Pat's sitting at her desk at a laptop and has her phone surrounded by papers and is struggling with some things. And then the phone will ring and the conversation will begin. It's called Probate Problems.
Hello.
Hi, Pat. Am I interrupting something?
No. Yes.
Well, I'm calling to see if you want to join me for a walk. I thought I'd head down to the waterfront bike path.
Oh, Corey, I can't, much as I'd like to. I'm up to my eyeballs in paperwork. It's got me so confused and frustrated, I can't even think straight.
Paperwork? I thought you were retired from teaching.
I am, but I did something stupid that I thought would save both my kids and me a lot of time and money. And now it's costing me plenty of both to try and straighten it all out. Believe me, it feels like a full-time research job right now without pay.
Wow, sounds bad. Is there anything I can help you with? Once a CPA, always a CPA.
Certainly what I need now is a lawyer. Sure wish I'd consulted one before I got into this mess. The legal fee would have ended up much cheaper than what I've spent already.
What's happened? If you don't mind my asking.
I'm almost too embarrassed to tell you. I feel like such a chump.
Well, in my experience, talking things out loud often helps you clarify things, helps find a solution. I'm sure you taught that to your students.
All right. I got this offer in the mail. It was so official looking and so informative. It offered me a way to arrange things so that my kids can avoid having to go through probate court when I die. It explained how expensive and time-consuming the probate process can be, so I thought I'd really be doing them a favor by easing the process for them. So I signed up.
Well, that sounds like such a thoughtful thing to do. Your heart is certainly in the right place, but it also sounds too good to be true.
Well, it sure turned out that way. I ended up spending a sizable chunk of money for documents that, as it turns out, aren't even legal in Vermont.
Ouch! That sounds like an expensive lesson.
Oh, and that's not the worst part. In order to prepare this document, they requested my social security number, as well as the names and social security numbers for all my heirs.
Oh, no, Pat. Oh, please tell me you researched the company that sent you this mailer. Once a professor, always a professor, right? Was this company a reputable one?
Well, I thought it was. I thought it was from AARP, so I didn't feel the need to check them out. After I found out the document wasn't legal in Vermont, I looked more closely and saw that the company who sent it was called AARPC.
I've never heard of AARPC. Is that a division of ARP?
Unfortunately, no, it isn't.
Oh.
Turns out there is no such company. When I tried to reach them, I found out that they had no phone and their location was bogus. The address is just a Dropbox and one that's already been closed.
Oh my Lord, Pat. Taking your money's bad enough, but you actually jeopardized your personal information as well as your kids by sending their full names and social security numbers?
And my grandkids.
Oh.
I've spent hours researching what we need to do to keep this from ruining everyone's lives. Not only is it costing me much more time and money, but now it's costing them their time and money as well. All because I was too cheap to consult a lawyer first. Oh, what a nightmare this is.
Well, I hope you've consulted your lawyer now.
Oh, I sure have, but the damage is done and it's all my fault. Furthermore, probate costs are minimal. Should have checked that out too.
How's your family taking it?
Well, most of them aren't speaking to me, and who can blame them? I feel so stupid. Me, the retired professor. Should have practiced what I preached about due diligence. I've let them all down.
Holy cow, Pat. Well, it sounds to me like you could really benefit from some fresh air and a good friend to vent and brainstorm with. Let's take that walk. What do you say?
Well, maybe you're right. My head could use a little airing, and maybe the exercise will ease my tense muscles.
Great. I'll pick you up in 10. Bye.
Okay, see you then.
And curtain.
I'm glad I'm not that lady.
Yeah, me too.
All right. Well, we're not going to be as good as that, but we'll go on to our first scenario. And the players in this scenario are Claire, who's a grandmother. Claire's husband, Thomas, has passed away, and Claire has 5 children. And Claire's house is paid off, and Claire's just retired. So she has a 401k with a sizable amount of money in it, but she's not rich by any stretch of the imagination. And what's important to Claire is that she wants to help her grandkids pay for college, but she also wants to pass some of her assets on to her children. And so Caroline will talk a little bit about what are some of the things that Claire should be considering.
Thank you, Dave. And I really enjoyed the probate problems. So thank you for that skit. Excellent performances. And I like the too good to be true. That's good advice indeed. So thank you for that. So Claire. So what I'm going to do in each of these is kind of give you some tips. And Claire and I ordinarily would have sat down And we would have talked for what's called an estate planning consult. And that is something that I offer free of charge. It is 1 hour. And I ask my clients to fill out a questionnaire in advance. And they send that to me through, by the way, a secure legal portal. So unlike in the probate problem skit, no personal information is shared with others. And then we sit down after I've got that information, we sit down and we have a consult and we talk about all the tools, the elements of an estate plan. We talk about the options available. If I had talked to Claire and she had expressed her wishes and her goals in that estate planning consult, I would have told her a few things. First of all, I would have said, Claire, as I tell all my clients, please create a will. I consider a will to be a cornerstone document of any estate plan. And although I also tell my clients that we need to have that cornerstone, that foundational document for our estate plan, we're also going to do everything we can so we never have to use it, meaning we never have to go through probate. So the first thing I would tell Claire is let's create that cornerstone document that expresses your wishes to pass assets to your children. We would designate those assets. Your wishes to help your grandkids with higher education costs. We can also create some elements of your will that do that or express that goal. And that would be what we call the safety net of an estate plan. If all other methods of trying to pass those assets according to Claire's wishes fail, then her will capture those wishes and those goals and make sure that she has that safety net. So the first piece of advice, create a will. The second piece of advice, possibly Claire might be someone who might be interested in what we call a revocable trust. And a revocable trust is an instrument that essentially designates certain assets as being under the umbrella of what's called a trust, a legal entity. And in that case, what Claire could do when we created this trust was she could put all of these assets, her home, her 401k proceeds, into that revocable trust. And the revocable trust would have essentially a design, a plan for distribution that would allow her to determine what sort of elements of her assets or percentage of her assets she wants to provide to her children. If she wants to provide certain elements of her assets through trust to her grandchildren, she would designate a trustee, a person who's responsible for that distribution and would be able to distribute those assets according to her grandchildren's needs. If they're going to college or private school or whatever they're looking to do, Claire could be very specific in the trust language to determine how those funds would be used. The beauty of a trust is it is something that is outside of probate. You can put your assets within its umbrella, all of your assets really within its umbrella. And it's a private way to distribute your assets. Unless there for some reason is a contest or a challenge to your trust, there would never be any reason for any court or any other person to know anything about your private trusts, your wishes, your goals, and how those wishes and goals are fulfilled. So that would be another tip I would give her. The other element I would probably mention to Claire is what we've talked about in the past, which will recur throughout this exercise, beneficiary designations. There is something in Vermont called an enhanced life estate deed. An enhanced life estate deed allows you to pass the title to your primary residence to a person or persons we call in the law remainderment. The enhanced life estate deed allows you to do whatever you want with your property while you're alive. You can sell it, you can mortgage it, you can renovate it, you can do anything you want. You have the complete bundle of property rights during your lifetime. However, at the moment of your death, instead of your home going through probate, the title of your home would transfer seamlessly to the individuals you name as remainderment. So that's another strategy that might benefit Claire if she's looking to avoid probate costs and complexity for her children and pass on some of those assets to either her children or her grandchildren. So Dave, those are some of the tips I would give to Claire.
Thank you, Caroline. And one example that I want to share from personal experience or experience with my clients here is often in this scenario with somebody who has multiple children, it is possible that one of those children maybe not as financially responsible as the others. And the trust that Caroline talked about can help prevent against a spendthrift child burning through the assets that mom worked so hard to save for. And you can use the trust to do things like parcel the money out over a period of time. And it just gives the individual the control to be able to maybe provide for a longer lasting inheritance for one of their children. Okay, so we're going to go on to act number 2. So act number 2, we have Roberto and Maria. They've been married for 18 years and they have 2 children, Olivia and William. One day they hired a babysitter. They went out for dinner and a movie. And on the way home, they got in a car accident. And unfortunately, Roberto did not survive. Maria survived, but she's in a coma. Now we think that this type of scenario, and we hope this type of scenario wouldn't hit our family. But if it did, we'd have these questions. Who will take care of the kids? And who's going to pay for the mortgage with dad gone and mom in a coma? And what's going to happen with my kids? So Caroline, what kind of advice would you have in this situation to help prepare for such an unfortunate event?
Yes, so William and Olivia's, or Roberto and Maria, I'm sorry, those are the parents. Their situation is not unusual. I met with a client this morning who is a mother and she has 3 young children. And she talked to me about estate planning for her and her husband. And she said to me, the reason that they have never done a will, the only reason really they've never done a will, even though they know they need to, is because they can't figure out who would take care of their children in the event of their deaths. It is a pressing question for all parents. And so that is a reason that many young parents avoid taking care of these responsibilities and making sure that their children would be provided for. So a will or a trust can designate a guardian for children in the event of a parent's incapacity or death. If there is no will, then what would happen is it would go to probate and it would also go through a guardianship proceeding, which could be contested. It could create some concerns. And frankly, the person who ends up taking care of the children, legal guardianship of them, might not be the person that the parents had hoped would continue the love, care, and instruction of their children. So in a will or a trust, young parents or parents of any age can designate guardians for their children, those individuals who would take legal responsibility of them after their incapacity or deaths. So that's one example. Covering lost income, pay the mortgage, meet medical costs. Well, in that case, again, that is where I think we would get into the issue of, again, a trust or a will. A trust can create an ability to take assets and have certain distributions made for the benefit of medical costs, lost income, mortgages, etc. If one of the parents became incapacitated, but the other one did not, that's an example where a durable power of attorney could be used so that the competent parent could use that and demonstrate that they had the capacity as a financial agent to take care, to access assets of the other parent and to pay those mortgages, those medical costs. So there are a variety of strategies too, Dave, that we could use for that. In terms of taking care of investment decisions, again, if the will or the trust appointed a guardian for Olivia and William's education, or a trustee who would take care of the financial portion of Olivia and William's inheritance or those assets, that trustee or guardian would have the right to make decisions related to costs spent, funds expended for Olivia and William's education. So it's all in the planning. And what I would say to parents out there who have children who are minors and who are facing the notion of estate planning and fearful of it because they don't have the perfect person who would take care of their children. Well, no person will be you, so no person will be perfect in that scenario. But again, as we all know, don't let the perfect be the enemy of the good. It's much better that you take control and you're able to make that choice than to leave that decision to a court, because that's when things really can go south, unfortunately. Thanks, Dave.
And one example I want to share in this situation is a family that I was working with. the husband died, unfortunately, at a very young age. He had 4 children and a wife that was a stay-at-home mom. And unfortunately, he didn't have a large amount of retirement savings built because he had been, working so hard to provide for his family. Fortunately, he had a life insurance policy that paid for that allows his family to continue to stay in their home and get through this difficult time. So life insurance can be another key critical part of a estate plan.
And Dave, just to chime in there, life insurance policies can name a trust as a beneficiary. So the trustee then, the person who's responsible for using those assets to the benefit of the children, would then have control over those assets to use them according to the wishes of the decedent as laid out in the trust. So yes, Dave, life insurance is a great vehicle for that.
Okay, we're going to go through one last scenario and then we'll get to questions. So in this scenario, we have Patrick and Sharon. Patrick and Sharon have 2 kids. They've been married for 12 years, but this is Patrick's second marriage. And one day they're out on the bike path going for a bike ride, and all of a sudden Patrick feels a tightness in his chest and pain in his shoulder. And so they get really worried and they take Patrick to the emergency room. And good news, after extensive tests and an overnight stay, the doctor declared that Patrick was indeed in very good health. But this got them thinking, we are mortal. What should we be looking at? And so Patrick and Sharon decide that this is the time that they're going to go talk to their estate attorney. And Caroline, what are some of the things that you would talk to Patrick and Sharon about?
Well, I would definitely make sure that Patrick and Sharon, particularly Patrick, of course, but also Sharon, had created an advanced healthcare directive. And here's something that I will suggest to everyone listening to this, if you have not already created your own advanced healthcare directive. I tell my clients there's no reason to pay me to do that. The Vermont Department of Health has on its website wonderful forms that are compliant with Vermont law, that are extremely accessible. They're fillable on the computer. There's a short form and a long form that will allow you to make choices and to express your wishes in terms of what you would want to happen in the event that you're incapacitated and unable to express for yourself what sort of medical care or medical wishes or end of life care you want. And so I urge everyone, if you have not done so, to go on the Vermont Department of Health website, to look up the Advanced Healthcare Directive and to fill out one of those forms and get it registered with the Vermont Registry. So that's definitely, Dave, something I would make sure, certainly, that Patrick and Sharon had done. We talked a little bit about a durable power of attorney already. If Patrick had become incapacitated as a result of the heart attack and Sharon needed to access certain financial assets of Patrick's, which were not available to her as a joint owner, a durable power of attorney would have allowed Patrick to designate Sharon as a financial agent, which would have allowed her then to take advantage of those assets for Patrick's needs and care and the needs and care of the children. So that's another really important tool in the estate planning tool belt. I've already mentioned a will. Fortunately, Patrick did not get to the point where he needed a will, but certainly this near miss should suggest to him, particularly with respect to the children, as we discussed, any designation of a guardian for them. That's a super important element. And finally, it indicates that Patrick is in his second marriage. And I'm going to give you a personal example of a big mea culpa and just let you know that I'm in my second marriage as well. And I remarried 5 years ago, and I was divorced about 11 years ago. And I realized about 4 or 5 years after my first marriage had ended that I had not gone back and redone my beneficiary designations on my bank accounts. I had done it on other things, but not my bank accounts. And so Patrick should definitely do a little due diligence himself, as somebody mentioned in the probate problems, do a little due diligence, go back and look at his financial asset designations, including bank accounts, and make sure that Sharon is either on those accounts or she's the beneficiary designate. Life insurance policies, of course, as well, and all other financial assets. So those are some of the tips I would give Patrick and Sharon, Dave.
Great, thank you, Caroline. I just want to give one more example. One thing that you mentioned resonated with me. It's very important to check your beneficiaries, make sure you have beneficiaries established. As we said before, if you don't have beneficiaries established, then the state of Vermont decides or dictates who your beneficiaries are. And I had a family example where one of my relatives had a life partner, but they weren't married. And when he died, they did not have a will, and so legally she had no right to his funds. It was settled through a complicated court process, but it could have been a whole lot easier with the simple addition of a beneficiary.
And also, Dave, just to chime in on that, of course, it's important to emphasize that one of the best reasons to designate beneficiaries is not only to ensure that you're benefiting the people or causes that you adore and love, but also you're avoiding probate, because those beneficiary designations result in passing by probate, going directly to the beneficiaries. And so that's a lovely way to make the probate process either non-existent or much, much cleaner from your executor's perspective.
So to sum things up, I would say that one of the most important parts of a estate plan is that in the estate plan, you are maintaining control. You're maintaining control over who you want your assets to go to. You're maintaining control of who makes important decisions for you if you are not able to make those decisions for yourself. You are in control of who is going to take care of your minor children or dependents. You will have control whether you want to make charitable contributions, and you'll have control over the tax implications of your passing.
And Dave, if I can chime in, aside from control, there's also another not inconsequential benefit, and that is peace of mind. I had a couple execute wills today in my office and leave my office, and the woman expressed to me she felt lighter. She felt like she could live forever. While I don't guarantee as a result of doing estate planning with me that you'll live forever, I do think that it makes you just feel more secure and have that peace of mind, which is definitely a quality of life issue and definitely can't hurt in terms of longevity. So also good benefits of estate planning.
So I'll stop here and let me share this. If you have, we have time to take questions. I don't know if we want to do that before or after the final skit. Anita or Richard, you could give us guidance there. But feel free to reach out to Caroline and I if you have any questions. We would be happy to have a further conversation.
Just so you know, our final skit is intended to be a wrap-up, so it's probably best to do the questions first, and then we would close things out.
Okay.
Sounds good.
Great. So we'll open it up. We'll open it up if there's any questions.
Anita, do you want me to go through the chat box? Because I'm seeing questions in here.
Sure. Yes, I'm noticing some too.
Okay, so hopefully I answered the question, how is this different from having a will? A will is a component of an estate plan. So it's an essential foundational element of an estate plan. It's part of the estate plan. So that's the answer to that question. Isn't this just for the rich, which is a great question. And in fact, no, estate planning often is the most beneficial for individuals who have modest assets, or as I am, are worth more dead than alive because of life insurance. So oftentimes, estate planning is in fact for folks and benefits folks tremendously of any income bracket, really. So let me keep going here. And yeah, feel free to jump in, anyone, and mention any other questions. Life insurance is absolutely a component of estate planning. Dave has talked about that a little bit. And as I mentioned, beneficiary designations in life insurance can definitely be a trust or can contribute to the kinds of provisions you're making for your loved ones. How often, great question, how often should a person or couple look over their will? So I'm going to give you 2 guidelines. The first one is every 5 years. If your life is just going along smooth and there's been no hiccups or no major events. The second guideline I will give you is that if you have a major life event occur, the near miss that we had in one of our scenarios that Dave discussed, perhaps a divorce or a remarriage, perhaps you have children, perhaps you receive an inheritance that is worth considerable amount of money or property. Those are great moments to really consider consulting with your estate planning attorney and looking again at the estate planning that you have done to see if it has continued to grow with you or if you need to take a different strategy. So major life events are good moments in general to take a look at what's going on with your estate plan and if it's still serving you well. Assets and income levels being addressed. I'm not sure, again, various assets and income levels benefit from estate plans. There are different approaches to those. Right now, under Vermont law, there is no estate tax on estates that are under $5.1 million. Most of my clients do not have assets to that level, so they don't have to worry about estate tax, but I do have clients that do exceed that. And so in those instances, there is some planning that can diminish the taxes that are levied against their estate upon their death. Let's keep going here. For Caroline, if you have your house in a trust, would you also need the enhanced life estate deed? The very short answer to that question is no, you would not. The trust, your house would be in the trust's name, and then the house would be a trust asset, which can be distributed or used according to the express wishes of the trust as outlined by you, the trust. So that's the answer to that question. Irrevocable trusts, don't they cost a lot to create? And doesn't it mean that I would not have access to the assets in it? I gather irrevocable means one can't change it once it is created. So trusts, that's a good question, Kathy, for a number of reasons. Trusts in general are not inexpensive tools of an estate plan. In terms of my estate planning, trusts are definitely the most costly aspect of my services if they are something that is considered or is useful for a client. So trusts are expensive. But there's another aspect of trust that's important to consider. And I have many clients who stumble once they've created a trust in this way. And usually I haven't, in all instances so far, I haven't created the trust for them, but they've come to me with a trust. And what's happened is they've spent the money, which is not an inconsiderable sum of money, to create the trust. And then because trusts are complex to administer, they require that you do certain things and that you do them completely, thoroughly, and well. Sometimes they don't understand what the folks who have created the trust don't understand what they're supposed to do, what their obligations are under the trust. And as a result, they don't get the benefit of the trust. So they've spent some money and then they're not getting the benefit of the trust that they created. And so I generally counsel clients, creating a trust, whether it's revocable or irrevocable, is a serious matter. And you want to make sure that you're ready for the administrative responsibilities of creating a trust.
Caroline,
yep.
I just want to chime in on something there.
Yeah.
That's why it's so important to have that team approach that we talked about before, because I've seen the same thing where somebody will create a trust, but due to communication or misunderstanding, they won't put their assets register their assets under the trust, or you know, other the trust isn't really what they wanted to accomplish, or because they didn't take beneficiaries off an account, it never had a chance to get into the trust. So very important that you utilize that team approach between the attorney, your tax professional, and your financial advisor.
I agree, Dave. And the other thing is that I can tell you that I don't think there's a single client who has come to me yet with a trust that another attorney has created for them, who has thoroughly and completely understood what a trust is and what their trust provides. I really make it my mission that if my clients are going to work with me to create an estate plan, they're going to know what it means, and they're going to make sure they understand it and they can actually act on it. So that's really, trusts again are complex. The irrevocable in general does mean there are very limited legal exceptions under which you could invade an irrevocable trust. An irrevocable trust is a trust that is established, and under law, 99.9% of the time, you cannot change the terms of that trust. Once the assets are placed in that trust, it's a one-way street. They go in, they don't come out, except under the strict instructions of the trust as delineated in the trust. So creating an irrevocable trust is another layer of complexity, another layer of planning that can be beneficial in certain circumstances. But it is important to understand exactly what you're creating and whether you can comply with the obligations of the trust.
But there's also a lot of benefits to revocable trusts.
Absolutely. Revocable trusts are often very, very beneficial and can protect your assets in certain ways. As we discussed earlier, they can avoid probate and distribute your assets by avoiding probate. They can ensure privacy of the distribution of your assets and your wealth, which is often something that people desire. So and they can attach the kind of provisions, Dave, that you talked about, like a spendthrift provision, to make sure that a particular individual who might not be as good with money can actually have the benefit of protections like that. So there are a lot of options under revocable trusts. And Patty asked, if this did happen, a living grandparent would not be the family member who would be the person who the court suggests the children go to next of kin. So I want to make sure, I think I understand the question. I think the question is, if there wasn't I think the question may be, if there wasn't a will, what would have happened to Olivia and the other young man who was the child in that couple, if there was no will and both of the parents, passed away? In that case, the court would have a probate hearing, and the court would throw it open to any family member or even a friend of the family who believed that they should be the guardian of the children and that the children should be placed in their legal guardianship custody. And that's where that kind of a court hearing can be very contested, particularly, by the way, if that particular child is the benefit of a pretty significant amount of wealth. That can be also extremely contested, and unfortunately, sometimes some folks might not have the best interests of the children in mind, but rather the wealth that's behind the children. So, again, most instances that doesn't happen unless you're talking about super wealth. But again, the court will make the best decision that they can make. I believe that I've been in front of almost every judge and court in this state, and I can tell you that again, judges that I've met want to do the right thing. But they meet you for a day or two. They don't know you for 10 months, 2 months, 12 years. They meet you for a day or two, and they do the best based on the evidence in front of them. And that comes to children as well. They do the best they can, but they can't possibly know it all. And so that's why leaving that kind of decision in the hands of the court is a dangerous gamble with children's, I think, well-being.
Just a comment there. For the relatively low expense of a will, why would you want to let somebody else fight over who are taking care of your children?
Yeah, absolutely. Absolutely. At what age should a person or couple set up a will? I would say at any age. I've had, folks as young as 25 come in and set up a will with me. And I applaud them for their forward thinking. I've had folks as old as, their 80s come up and set a will with me. So, at any age, someone can benefit from planning. And you can always revise your will, grow with your will, sort of reevaluate it. But really, any individual who's working, who begins to accumulate assets, and or who has individuals who depend on them would be definitely benefited by setting up a will and having that security and peace of mind. I think this might be one of the final questions. Can Medicaid costs be attached to an irrevocable trust? So the concept of Medicaid is a really interesting one. It's a very big topic, and it's probably much too big for this particular seminar. Very quickly, what I will say to you is this. One of the reasons that it is really a good idea to try to avoid probate is because in Vermont Medicaid will not go after any assets unless they are in probate. So if you have had a spouse, let's say, or you yourself have used Medicaid to be in a nursing home, and then you pass away, and you have assets that were guarded from the Medicaid calculation, and they went, like, say, your primary residence, and that goes through probate, Medicaid is entitled under law to attach the assets in your probate estate in order to recoup, to get back the money that was spent on your care when you were in the nursing home before your death. So they can go after those assets that are in probate. Vermont Medicaid, while it has the legal right to do so, at this point has never attempted to go after assets that have passed outside of probate. So if there's a life insurance policy that's going to a particular family member, or if there is an enhanced life estate deed for your home that is titling your home directly to a remainder person, a beneficiary, without going through probate, Medicaid in Vermont does not have the practice of attaching those assets. So you can protect those assets with planning from a Medicaid lien. And again, that's a huge topic. I probably told you things that are making your head spin, but that's a big topic for another day, but it's a great question. Should a person who has a will give a copy to who they assign as an executor? Fantastic question. Absolutely 100% yes. For the one big reason is because maybe they don't want to be executor, and you better find that out sooner than later, because if you're relying on them and then they say, I don't think so, Judge, then you're back where you started and there was no point for a will to begin with in some sense. So absolutely make sure you discuss it with them. My father, again, a beautiful example of planning. Every year my father met with me. We went through his binder, his estate planning binder. We talked about his assets and where things were. And he asked me if I had any questions. He always ended it, do you have any questions? And if I had a question, I had the opportunity to ask my father then. You don't have that opportunity after they're gone. Now is the time to discuss these things, to make sure everyone understands what the responsibilities are, to let you know if they don't want to assume those responsibilities, and to make sure that everyone's on the same page. So definitely great question. Yes, yes, yes is my answer. And yes, my estate planning consults are free. The initial estate planning consult is absolutely free. You can come in and meet with me for an hour, and we talk about your, I send out a will questionnaire, an estate planning questionnaire to prospective clients. You fill it out, you send it back to me, and then we can meet virtually, right now virtually by Zoom or by phone, and we can talk about your goals, wishes, and what I would perceive to be potential tools of an estate plan that might really work well for you. Could you say something about life estates? So I want to make sure I'm understanding. Penny, can you tell? I'm not sure I understand your question completely. Maybe you can elaborate. If Penny's there. Penny, are you there? Okay, so I'm going to move on. If Penny is there, if she appears, she can ask. Can I have two people as healthcare proxy or power of attorney? So you can. I don't recommend that. The reason I don't recommend that is because where you have two people, you have the potential for tension or for disagreement. And so my recommendation is usually that folks have appoint a healthcare agent or a durable power of attorney financial agent, and then they appoint a successor agent, someone who would take over in the event that the first appointed agent is incapable or doesn't want to take on the duties. That is the way that I would recommend it. I have had clients who have kids, 2 kids, and they don't want to show favoritism, so they insist on having them as co-agents. I accept their determination, but I do always make sure that they understand that I think there are risks associated with that. Not only from just a decision point of view, but also from a practical point of view. If there are two agents, they have to both indicate weigh into, financial folks, et cetera. And that just is, is a complexity. Burial plans and funds for funerals. You can cut me off anytime, Anita. I'm just going on with the question. So if I'm taking too much time, burial plans and funds for funerals. So you can put up to $10,000 in a burial account, and it will be carved out from any Medicaid eligibility. So if you have not pre-purchased your funeral arrangements, which by the way is a good idea, but if you decide not to do that, you might want to set up a funeral account that's designated in that way. And it can contain up to $10,000 for funeral arrangements, which can then be accessible to your executor in order to create your funeral and arrangements. In terms of burial plans, the Advanced Healthcare Directive form that I mentioned at the Vermont Department of Health has a section that you can fill out that indicates what your preferences are for your burial. It indicates whether you want to donate particular organs or what your, if you have an interest in that. It talks about, it allows you to put in if you have particular pieces of music or the type of service that you'd like performed in terms of a funeral service. So there's a lot of options on that form to express your wishes so that your healthcare agent and your executor will carry out those wishes. So what is your fee after the first free hour? So what I do in that hour, that consult hour, what I do is I meet with you and we discuss your needs and your goals. We talk about what I would recommend. Then if you decide to move forward with me, I give you everything that I do, the services I provide are at a flat fee. So I would tell you, well, it's X dollars for a will, it's X dollars for a durable power of attorney. You would choose whatever elements of the estate plan make sense to you and are workable for you and affordable for you at that time. And then we would proceed along those lines. So the reason I do that is because I want people to understand the complete cost so they don't have to worry about me spending all the time I want to and about the ka-ching going up if I'm billing you hourly. I don't do that. The other thing I just want to mention here is that the estate planning process is not an all or nothing process. You might decide you want to take one step today. You want to do a durable power of attorney this year, and that's what you can afford. And then maybe next year you want to do a will, or maybe the year after that, you want to do an enhanced life estate deed. Any step you take is a good step, and you should pat yourself on the back for taking it. You don't have to jump. You can take a step. So it's not an all or nothing proposition, and we can obviously work within your budget and within your needs. I'm going to close there because I don't want to take up too much time. I put my email and my phone number in the chat box. My phone number, my office phone number is 802-225-6495. I'm happy to answer questions. Or my email is CSE, my initials, CSE@earlfreemanlaw.com. So, please feel free to shoot me an email if you have an additional question. The only other thing I'll mention to you is that I'm in a business group which meets on Thursday mornings, and I'm giving a presentation next Thursday morning on do it yourself in estate planning, worst pitfalls and best practices. There are elements of estate planning that you can safely do yourself. If you'd like to join us at that business meeting, please feel free. It's 8 a.m. to 9:30. I'd be happy to host you for my presentation. Just let me know, shoot me an email, and I can get you registered. Thank you very much, all. Thank you, Anita.
Thank you, Dave. Thank you, Caroline. I don't see any other questions, so the Savvy Seniors can wrap us up with the third skit.
Actually, Anita, can I chime in with just one last wrap-up thought?
Sure.
We talked a whole lot about the estate planning process being about preparing for what happens when you die, keeping control. One thing that I really wanted to highlight that has hit home to me personally recently, often when you're a couple, one of the couple is the financial person. They pay the bills, they know where the accounts are, et cetera, et cetera. One thing that I would encourage everyone to do as part of their estate plan is sit down with your spouse or your significant other and make sure that they know about all of your assets, about all of your accounts, who to call. We had that happen recently, and trying to find where everything is when the financial person has passed is very, very difficult. So just make sure you share that information. All right, thank you, Anita, appreciate it.
That's excellent, Dave. Good tip. Good tip indeed. So Richard.
So our programs are usually about 45 minutes in length. We do more than 3 skits for them. And at the end of each program, our host or moderator or MC will give a summary of what we've been talking about. In this pandemic era, we thought maybe we should do something a little different. So Peggy Bonesteel wrote a summary skit for us called Savvy Roundup, and we're going to share that with you at this time. I want to express our appreciation for this really fascinating program and very informative and very helpful for a lot of people, I think. And thank all of you for joining us and sharing in this exchange. And I want to thank the Savvy Seniors for being a part of the program as well. And I would like to reintroduce them to you. We have Peggy, we have Audrey, and we have Kimberly. And remember, I have to ask my Savvies to unmute themselves.
Done.
Right.
And remember which parts you're supposed to be doing here. Okay, now, and remember.
Okay, and if you haven't initiated the contact, don't ever give bank account information to anyone via the phone, text, email, or Facebook.
In fact, don't answer the phone at all if you don't recognize the caller. If it's a legitimate call, they'll leave a message.
And don't give your credit card information to anyone you're not absolutely sure is working for a legitimate business. Ordering a pizza or a sweater from LL Bean is fine, but beware of the internet or phone come-on calls that are selling medical supplies, COVID vaccination lists, or whatever. They're most likely scams.
Remember, at the current time, there is no vaccination or cure for COVID-19.
Beware of pop-up COVID testing sites in parking lots. If you see one, call the health authorities to make sure that it's legitimate.
Beware of any contact asking you to get and send gift cards for any reason. That email might sound like it's coming from your cousin Harry, but be sure it is before buying and sending anything.
If someone calls you to tell you that you won a sweepstake, congratulations. If they tell you they need money to pay for shipping and handling of the prize, hang up.
Don't click on any computer links that you aren't absolutely sure that you recognize.
Oh, is there anything positive we can do?
Absolutely.
You can go to the websites of trusted charities that you want to help out financially.
You can stay in touch with your family and your friends, and we all need friendly voices right now. If there's something that comes your way that sounds fishy, contact someone you trust and get their input before doing or clicking anything.
You can visit aarp.org/scams to learn about the latest coronavirus, the virus scams.
Most importantly, you can keep yourself safe.
Wash your hands.
Stay at least 6 feet away from other people until you hear something different from the authorities.
Get plenty of sleep and drink plenty of water, although those things might work against each other a little bit.
You can see that sometimes this whole COVID-19 experience is a fluid kind of thing. There are actually, we say in the skit that there is no vaccine, but there are actually vaccines out there. There is no cure, and the vaccines are still experimental. And so we want everybody to know, pay attention to what the health authorities and the medical people are saying about the current status of COVID-19. All in all, What we are trying to say is be well, be careful, and be safe. Again, thank you for being a part of our program this afternoon.
Yay! Well done.
Thank you. Good job. So Marichelle, I don't know where you went to. I think we're kind of wrapped up here. I don't know if anyone has any other questions that they'd like to put out there that I can address, or one of us can address really quick, but we're coming up on time. So
Yeah, thank you, everyone. Thank you to the Savvy Seniors, to Caroline Earle, to David Gold.
yeah,
This has all been recorded, and this will be up on our YouTube channel, which we hope to have the link on our website, which is vermontelders.org. In 2 weeks, we will have another COVE presentation. It is called An Armchair Hike with Helen Hossley, who was a park ranger. And she was a park ranger out west. And so she's going to talk about her experiences as a park ranger and share photos and stories of her adventures during that time. So please join us for that. And you'll probably get an email about that registration link. So thank you for joining us today, and please join us for future presentations. Have a great afternoon, everybody.
Thank you.
And thank you, Anita and Marichelle and all for putting this together. It's great.
Thank you, Jim.
Thank you.